Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's Wrong with Having Lots of Patents? Patent Thickets and Antitrust Law. We're standing at the crossroads of patent law and antitrust law, with dueling public policies, one favoring the protection of intellectual property rights, the other favoring competition on the merits. We'll hear more details about the dilemma posed by so-called patent thickets in this crossroads in today's episode. But first, let me introduce my co-host, Lijun Zhang. Hi, Lijun.
Hi, Alicia.
Would you like to tell us a little bit more about what's going to happen today?
Sure. So speaking of patent thicket, it is a situation where one firm holds a massive number of related or overlapping patents. For example, in a pharmaceutical context, behind a single drug, there may be hundreds of patents that a competitor firm has to evaluate and possibly challenge before it can launch a similar drug. So as we will hear in this episode, patent thickets illustrate the tension between patent laws and antitrust laws. On the one hand, patents are presumed valid, and until proven otherwise, they grant constitutionally protected exclusivity to the patent holders. On the other hand, however, it may be commercially impractical for a competing firm to challenge each and every one of the hundreds of patents to pierce through a web of exclusivity. This potentially creates a specter that the patent thicket might have been erected with an anti-competitive purpose or in an anti-competitive fashion. And we may never know it for certain because arguably no one would have the grit or wherewithal to challenge all the underlying patents. So our guest today is Kate Swisher, an antitrust litigator in the New York office of White & Case. Kate's practice focuses on the intersection of intellectual property laws and antitrust laws, especially in the pharmaceutical industry. She received her JD degree from Northwestern University and has an undergraduate degree in music and education from Yale University. Welcome to our Curious Amalgam, Kate.
Thanks for having me.
To kick it off, most of us are familiar with the idea that one or a handful of patents back up a successful product. When we talk about patent thickets, exactly how many patents are we talking about for a particular product? Can you give us some examples?
Sure. So I first want to note today that my remarks are purely my own, not my firm's, and are offered for purely academic purposes. But maybe the best place to start is to talk about what is at issue when you say patent thicket. It's a portfolio of patents that covers an invention or product. There is no accepted definition of what a patent thicket is. The phrase is label that has been used by those who wish to challenge an innovator's patent portfolio under the antitrust laws. But because there is no widely accepted definition, there is no magic number or threshold at which one might contend that an innovator's patent portfolio becomes, quote, a thicket. Perhaps you might even challenge the term thicket because this label is used by antitrust plaintiffs to connote a certain gamesmanship, like your patents are something to be overcome or hacked through, as opposed to legitimate protection for your inventions. And we should definitely not assume that successful products have only one or a handful of patents that cover them. In short, one woman's thicket is another's robust patent portfolio. So whether there is any merit to an argument that an innovator is using some number of patents to hinder competition will be highly fact-dependent. As for some examples, antitrust plaintiffs have challenged products covered by hundreds, if not thousands, of patents. And even in those cases, the analysis really depended on the conduct of the innovator, not the number of patents it had obtained. For example, in 1981, a competitor challenged Xerox's portfolio of over 2,000 patents covering its copier technology at the time. The Second Circuit there held that Xerox's patent portfolio did not constitute an antitrust violation. In the late 1990s, P&G owned over 250 patents covering its disposable baby diaper technology, which were challenged by a competitor as a thicket that violated Section 2 of the Sherman Act. But likewise, in that case, the District of Delaware held that P&G's patent petitioning was protected conduct under the First Amendment. In pharma, one patent portfolio that was challenged under the antitrust laws was AbbVie's 132 patents covering its blockbuster biologic product, Humira. A group of indirect purchaser antitrust plaintiffs challenged AbbVie's Humira patent portfolio, and the Northern District of Illinois dismissed their claims, and the dismissal was upheld by the Seventh Circuit in August 2022. And the court explicitly said that there's nothing wrong with having a lot of patents.
Okay, and we'll talk a little bit more about that case in some more detail later on. A quick question. Do you know when was the term patent thicket first used in a court case?
I believe it was the Xerox case in 1981.
Oh, okay. So it goes way back. Okay. And for people who are not landscaping experts, a thicket really is quite literally a dense undergrowth of underbrush, right? And shrubs that all link together. So it's an interesting metaphor.
So is it fair to say that the modern economy is giving rise to more products that simply must be sponsored by massive number of patented technologies? And will those potential patent thicket be more prevalent going forward? Like more plaintiffs are going to challenge more products in the future?
I think it can't be disputed that with technological and medical advancements will come more patent protection for those processes and inventions. In the high-tech industries where we see computer products that implicate multi-component technology, that will give rise to a larger number of patents covering the product. One well-cited estimate from patent aggregator RPX Corporation actually said that there are over 250,000 patents implicated by a single smartphone. But when it comes to complicated biologic products like Humira, it's pretty common to have many patents covering the many novel aspects of the complex product. And in part, that's because the process and the method of manufacturing a biologic is extremely complicated. And if you're not familiar, biologics are medical products that come from living sources like humans, animals, plants, intended to treat or prevent diseases. So a vaccine is an example of a biologic. But it should surprise no one that companies invest enormous research and development into product and research areas where they have had past success. And especially after the unanimous Seventh Circuit decision in the Humira antitrust litigation, which we'll talk about more, some biologic or brand manufacturers have reason to feel more comfortable seeking robust patent protection for their products.
So it sounds like patent thicket are behind a lot of innovation and technology advancement in our daily lives. So what are the plaintiffs' concern, or what are the antitrust concern implicated by patent thickets?
Well, when you're dealing with the intersection of IP and antitrust, the relevant question is whether there is tension between patents, constitutionally granted short-term exclusivity, and the antitrust laws, which disfavor exclusivities and monopolies if obtained by improper means. That's as compared to exclusivity resulting from superior products and innovation. And the often cited concern by antitrust plaintiffs and critics regarding so-called patent thickets is the potential for abuse or improper extension of that constitutionally granted monopoly. In the pharma context, these critics would say that patent thickets can present a challenge to generics or biosimilar manufacturers bringing their products onto the market, due to the volume of the innovator's patents and the associated cost and effort with challenging them separately through litigation. At the same time, it should come as no surprise that a company that has developed cutting-edge technology will have the greatest incentives and resources to invest in more R&D around that invention. And that R&D will in turn inherently produce more patents. But at the end of the day, a patent is presumed valid. So whether you have one patent or 100, a patent in and of itself cannot cause anti-competitive harm that the antitrust laws seek to protect.
I understand not only plaintiffs in those class actions label those behavior as patent thicket and criticize the practice, but also regulators or Congress weighed in on those antitrust concerns. Am I right?
It's correct that these issues have caught the attention of the Biden administration and regulators, as well as Congress. In July 2021, President Biden issued an executive order where, among other things, he cited concerns about the potential for patents to delay competition and urged the reexamination of the United States Patent Office's practices. In February 2023, the DOJ Antitrust Division urged the Patent and Trademark Office to do the same, citing patent thicketing and patent evergreening as two practices that could potentially impede competition.
And what is, sorry to interrupt, what is evergreening? We've I think, hopefully defined thicketing well enough for people. What is evergreening?
Patent evergreening refers to the procurement of patents with overlapping terms, such that the original exclusivity term is extended by the overlapping terms of exclusivity. But these initiatives have not been tested in the courts, and the record to date is that antitrust plaintiffs, including government agencies, will face an uphill battle. The concerns regarding patent thicketing have caught Congress's attention too. In June 2022, 6 senators wrote a letter to the Patent and Trademark Office outlining concerns with patent thickets. In January 2024, there was legislation introduced in both the House and the Senate proposing to limit a patent holder to asserting only one patent per terminally disclaimed group against a generic or biosimilar manufacturer. A terminal disclaimer is exactly what it sounds like. It's when a patent holder disclaims or gives up part of the patent term. So basically, they are agreeing that similar patents will have the same term of exclusivity. So the stated policy behind the proposed legislation is that for patents that are similar enough, generics and biosimilar manufacturers should not have to spend the time and resources challenging them separately. But the legislation does not propose to limit the number of patents that an innovator may assert that cover a non-terminally disclaimed improvement on a drug.
Is the legislation and the other policy arguments, are they generally in the context of focusing on the pharmaceutical industry specifically?
The legislation is part of an overall effort and attention focus on rising drug costs in the United States. So as part of the attention on the costs of prescription drugs, the Biden administration and Congress have proposed these initiatives and this legislation to address what they perceive to be potentially concerning practices in the Patent and Trademark Office.
Is it fair to say that those legislation and policy arguments are raised in response to the lack of success, as you just mentioned, of plaintiffs' allegations in courtroom? Like they couldn't get their theory approved in court, so there were more appetite to do the reform through other avenues?
I don't know that I could say that the two are connected. I know that this administration has been very focused on the costs of prescription drugs in the United States, and that these initiatives and the introduced legislation in January 2024 is part of that effort and that focus. The supporters of the bill say that it attempts to strike a balance between promoting innovation and encouraging competition. And if it is approved and enacted, it would have a significant impact on the frequency, the scope, and the duration of patent litigation under the Hatch-Waxman Act and the Biologics Price Competition and Innovation Act, which are basically the two regulatory frameworks whereby generic or biosimilar products come onto the market. So you can probably expect to see both brand and generic companies, biologic and biosimilar manufacturers, following this bill pretty closely. But whether any legislation will move is a very open question in 2024.
So in 2020, I understand a class action complaint asserted antitrust claims based on the so-called patent thicket against AbbVie concerning its drug Humira. And the case was dismissed by the district court. And again, in 2022, the Seventh Circuit upheld the dismissal. What did the plaintiffs allege in support of their theory, and why the court dismissed their claim?
So you may know that my law firm represented one of the defendants in the Humira appeal, so let me stick strictly to what happened in the allegations at issue. The plaintiffs in the Humira litigation alleged that in AbbVie's efforts to develop a patent portfolio covering Humira, it had developed a, quote, thicket. AbbVie filed 247 patent applications relating to the same compound, and 132 of those applications were granted by the United States Patent and Trademark Office. The plaintiffs argued that this portfolio of overlapping patents delayed biosimilar competition past when the original Humira patents in the U.S. expired in 2016. The plaintiffs also alleged that 90% of AbbVie's patents covering Humira were issued in or after 2014, after the product had been on the market for 12 years. The plaintiffs said that this indicated that AbbVie applied for these patents in order to improperly extend its period of exclusivity. The plaintiffs also alleged that AbbVie had obtained and asserted against the biosimilar manufacturers several patents that were invalid or irrelevant to the biosimilars products. And the plaintiffs contended that that risk and expense of prolonged litigation caused the biosimilar manufacturers to agree in settlement to a later market entry date, to the detriment of consumers. AbbVie, of course, responded that the patent application process is protected petitioning activity under the Constitution, and that the patents for Humira had withstood attack and were presumed valid. And the Seventh Circuit sided with AbbVie.
So it sounds like that case had a mixture of all kinds of behavior with great nicknames. We have the thicketing, right? We've got evergreening and pay for delay. Am I right?
That's correct. At a high level, that those three categories of claims were asserted in the Humira.
And with respect to the basis for the dismissal of the complaint, which for non-litigators means that the allegations of the complaint failed to state a claim. There was no discovery at any point, no facts were introduced. It's whether the allegations on their face sufficiently stated an antitrust violation. What legal framework did the Seventh Circuit rely on to dismiss the complaint? And I'm assuming with prejudice, that is, they were not allowed to try again and plead new facts.
Well, Judge Easterbrook wrote for a unanimous Seventh Circuit panel, which interestingly also included Judge Diane Wood, who is a prominent antitrust scholar, as well as who served as Deputy Assistant AG in the Antitrust Division of DOJ prior to her appointment. And in his decision, Judge Easterbrook wrote, quote, "What's wrong with having lots of patents?" Judge Easterbrook pointed to the Knorr-Pennington doctrine, which immunizes lawful government petitioning from antitrust scrutiny. Judge Easterbrook said that patent petitioning conduct like AbbVie's, so both the prosecution of the patents with the Patent Office to obtain them in the first place, and the subsequent enforcement of those patents against biosimilar manufacturers in litigation, were protected under the First Amendment. It's important to note that there is a narrow exception to Knorr-Pennington immunity if the petitioning activity is a sham. For this sham exception, the Seventh Circuit pointed to the two-pronged test outlined in Professional Real Estate Investors versus Columbia Pictures, and that's a Supreme Court decision from 1993. This test first requires plaintiffs to show that the challenged conduct was objectively baseless, and then to show that the subjective intent of the petitioning was to interfere with competition. The court said that AbbVie's applications could not be called objectively baseless because, quote, "after all, the 132 patents issued." The court also rejected plaintiffs' argument that AbbVie's enforcement of the patents against the biosimilars was anti-competitive because, according to the Seventh Circuit, the plaintiffs did not and could not allege that all the patents asserted in those litigations were irrelevant. The Seventh Circuit applied the professional real estate standard and held that AbbVie's petitioning conduct did not raise antitrust scrutiny. The court also pointed to the presumption of validity that every patent enjoys under the Patent Act and noted that a patent does not become invalid merely because it is narrow. A critical jurisprudential point is made by the court, challenging the heart of the so-called patent thicket theory. The court emphasized that there is, quote, "no cap on the number of patents an innovator can apply for or be granted." And Judge Easterbrook said, quote, "If AbbVie made 132 inventions, why can't it hold 132 patents?"
And you can understand, too, how coming up with some number that would be sort of too many patents could be completely arbitrary. Maybe it's something you decide on a case-by-case basis. Where is the line drawn? So I can certainly understand where the court was coming from in that respect.
Putting on the plaintiff's hat, however, is the Seventh Circuit saying that a plaintiff to be successful in this kind of suit has to prove all the patents are enforced in a subjectively baseless manner. And in this case, that means more than hundreds of patents. And as long as the enforcement of one of the patents has some basis, the plaintiff cannot bring itself into the exception of the Noor-Pennington doctrine.
That is the standard that the Seventh Circuit applied. I'll note that there is a circuit split over the standard to be applied to serial petitioning, so multiple acts of petitioning conduct as opposed to just one act of petitioning conduct. But in the Seventh Circuit, which is where the Humira litigation was, they applied the professional real estate standard and the test under that case, and found that since plaintiffs had not alleged and could not allege that every single one of AbbVie's asserted patents were irrelevant, that the petitioning conduct did not raise antitrust scrutiny and it was not objectively baseless.
Just to be clear, the petitioning means the prosecution of the patent before the United States Patent and Trademark Office?
The petitioning conduct refers to both the patent prosecution, which is the conduct before the Patent and Trademark Office, obtaining the patents in the first place, and also the subsequent assertion of the patents through litigation. Both of those are considered to be petitioning conduct, and both of them are protected under the Noor-Pennington doctrine.
Under the First Amendment. So you mentioned a case called Professional Real Estate. Is that a Seventh Circuit case?
That's a United States Supreme Court case in 1993.
And there was a circuit split. What's the split?
The split, I believe, is the Seventh Circuit and the First Circuit apply the professional real estate standard, the two-prong test, to both single acts of petitioning and serial petitioning conduct. Whereas I believe it is the Second, Third, and Ninth Circuits that apply a different test for serial petitioning conduct, but do apply the professional real estate test to acts of single petitioning.
We've been focusing our discussion on alleged patent thicket created through serial petitioning to the USPTO. Does it make a difference if a firm builds up a patent thicket through patent acquisition instead of its own innovation? Do courts apply a different framework to analyze this issue?
A patent is a patent. I haven't seen any case law that would indicate that courts would subject patents by acquisition to more or less antitrust scrutiny than patents granted through standard patent prosecution. The fact that patents are acquired or traded is not in itself problematic. Patents are property. Often a patent license or transfer will enable a more efficient firm to use a patent. An antitrust plaintiff will always have to contend with the strength of each patent. If there are enough patents that survive scrutiny, then the antitrust case will fail.
Okay, well, that's all very interesting information, and I think we've done a great job teaching listeners what the issues are surrounding patent thickets and their related behaviors. But before we let you go, Kate, we're going to ask you a couple of questions to get to know you a little bit better as a person and not just an antitrust lawyer. So the first question that I have, and I know a lot of listeners are interested in hearing about, is what advice you have for young lawyers or law students who are looking to get into antitrust.
I think I have two main pieces of advice. The first piece of advice is to speak to antitrust lawyers. There are many areas of antitrust law, and it is a wide, robust area of practice, and it's great to speak with people who are already practicing antitrust law to figure out, what areas might resonate with you and what you might be interested in. And I think there's no better way to figure out whether it might be a good path for you than to speak to somebody who's already doing it. And my second piece of advice would be to follow the news. So antitrust is a real hot topic these days. And following the treatment of certain antitrust topics by regulators, by the administration, and just generally by the media is a great way to stay on top of these issues and to figure out whether you want to make them part of your practice.
And listen to our Curious Amalgam too, right? One of the world's leading podcasts about antitrust and competition law, data privacy, and consumer protection.
Absolutely.
Now, the other thing I know our listeners are burning to know is something interesting about yourself that is completely outside of your professional life.
I don't know if this counts as completely outside of my professional life, but I am in a band. The reason I say it's not completely outside of my professional life is because I'm in a band with a bunch of lawyers. But the name of our band is Mistrial, and we're basically an 80s cover band, but we have a great time. And you should come and check us out at the Law Rocks gig at Gramercy Theater in October.
Oh, I have to do that. I am totally an 80s chick. I was there. I had the curly hair, and I had like big hair, big earrings. Still have them.
Love it.
And then to wrap this all up, we're going to ask you to play a little game we call The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game could not be more simple. I will ask my co-host, Lijun, to pull a random surprise question out of our virtual hat. So take it away.
Okay, here's our surprise question today. What popular singer or actor did you have a crush on when you were young?
That's a great question. Do you ask all the men that? I would say Jeremy Jordan, the Broadway star, currently starring in The Great Gatsby on Broadway. And, he was formerly in Newsies and Last 5 Years. Just a huge crush of mine back in the day and still today.
Oh, well, that's great. You're putting a spotlight on a Broadway performer, too, and not on some, household name pop star. So very good. Thank you again, Kate. Thank you, Lijun. Thank you to all of our listeners. And tune in to next week's episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.